And last Friday, Gledhill was in court for a hearing to address a pretrial protective order seeking to bar her from contacting her own children.
We'd like to address the protective order. We tried to address it with Commissioner Olson. He signed the pretrial protective order and basically deferred decision to the court, to you. So my question is, as a general matter, usually it's the state's motion to request the protective order. So I don't know how the court wants to handle it, if it wants the state to go first, or since it's my motion to dismiss a protective order that was granted by the commissioner, if the court wants me to go first.
I think since it's already in place, it would be appropriate to hear from you, Mr. Diaz.
Okay. Your Honor, I think that the pretrial protective order was incorrectly placed and allowed. The protective order, just so the court knows, is related to Ms. Gledhill's children. They are not named victims on the case. They are three individuals, 11, 7, and 5, whose father is currently missing, and we don't know where he is, and whose mother has been taken out of their lives. I think that granting a pretrial protective order in a situation where they are not named victims of any sort of domestic violence offense, there's no domestic violence in the presence of a child or anything like that related to the case, I think it steps outside of what the bounds of what a pretrial protective order in the domestic violence context are allowed to basically be put in place. I think the state's going to argue that the children are potential witnesses, at which point in time I would just argue that with them being potential witnesses, number one, we don't know if they're witnesses yet, but generally speaking, how the court handles that is the court can make bench orders, something that don't have criminal punishments attached. I think the overall frustrating thing for me in all of this is what this boils down to. This court is, I think, the inappropriate place to handle communication between my client and her children. There are other courts that are designed to handle that, courts that allow the children who should have an opportunity to have some sort of say, and they should be represented by someone like a guardian ad litem. This court, this venue, is not the place for that to happen. The children do not have representation. We don't know what they want. We understand they're young, but that's why in different settings, they're given guardians ad litem to speak for that. This order prevents any sort of venue of making any sort of modification where potentially mom could communicate with her children. I think that the request for a protective order is an overall heavy-handed kind of punishment. My client's already lost her liberty. At this point in time, it feels like the state and the city, the police agency that investigated this, are trying to set everything that my client loves on fire, essentially. To dig a little bit more into that, we know that the parents were arrested last night on no new information. Ms. Gledhill's parents were arrested last night with no new information. And it just feels like everything surrounding her, they're trying to take away. I think that this pretrial protective order is a part of that. And I don't think it's the appropriate venue. And I'm asking the court to remove the protective order and allow for appropriate courts to take that decision over. And with that, Your Honor, I'll pass to the state.
Ms. Paulus?
Yes, Your Honor, it's the state's position that the pretrial protective order is warranted. The case involves domestic violence. It's obviously very serious allegations against the defendant, and she is in fact the mother, the children's mother, and the victim in this case is their father. However, as Mr. Diaz indicated, at the very least, the state is requesting a no contact order in this case, preventing the defendant from having contact with the children. The basis for this request is the fact that that this is an active and ongoing investigation. These children are in fact potential witnesses. And the state is, in fact, open to readdressing a no contact order in the future once the investigation is more complete and the children on advice of potentially of a therapist. And I thought I'd be helpful to update you regarding the children's status. So they are currently in DCFS custody with a temporary placement with family. I believe the plan is for the children to start engaging in therapy in addressing the loss of their father and the fact that their mother has been charged with his murder.
So the judge lifted the pretrial protective order, but issued a no contact order to be put in place, kind of the same thing. That means Gledhill still won't be allowed to communicate with her children.